Hello everyone, Hashi Richards back with another video. So as you know, I'm an attorney based in Orlando, Florida. I practice within the state of Florida estate planning and throughout the United States immigration, so family immigration, as well as trademark law. And also within the state of Florida, if you have a personal injury case, a slip and fall, or a car accident, you can call my office 407-476-5320, 407-476-5320, because I co-counsel and refer those as well. All right, so if you watched my video yesterday, I said I was going to go over some of the ancillary documents that I mentioned yesterday. So in the context of estate planning, there are the documents that come into effect upon your death, right? So your last will and testament is one of those documents, right? Your will becomes effective the moment you pass away, right? Now, the documents called ancillary documents are really documents that are used during your life, during your incapacity, and also the document I'm going to talk about today, which is the living will, right? So the living will is actually used at the end of your life, right? So specifically here in Florida, the living will is a document where if you have an end stage condition or terminal condition, or you are in a persistent vegetative state, right? And two independent doctors agree that there's no likelihood of you recovering from this condition. The document, this living will, basically states that you wish to not have any life prolonging procedures done on you, right? Basically meaning don't keep you on life support and, to put it bluntly, pull the plug, right? So this is what this living will document says. And so if you sign this document, you're agreeing that if you're in any one of these three stages, end stage condition, terminal condition, or persistent vegetative state, that you are requesting that no life prolonging procedures be done on you, and that you basically are taken off life support. So this is a very, very important document. I advise all my clients to review this document if it's something they want, to sign this document, right, if they're in agreement with it. You may remember the famous case, the Terry Schiavo case, which was years ago, and she was a woman who was also married and had parents that were alive. She ended up in a coma, right, in an end stage condition, and her husband said, you know what, she told me that she wanted no life support and she wanted us to pull the plug. And her parents opposed that and said, no, Terry would have wanted to stay on life support and figure out, hopefully there was a way for her to recover, right? And so this ended up being a battle for over 7 years, right? Because she didn't have this simple document laying out her wishes, so no one knew what her intentions were. And eventually it ended going all the way through the court system, and finally they ended up removing her feeding tube, and I believe she died 13 days after the feeding tube was removed. A battle that didn't need to happen. It was unnecessary, and it caused a lot of heartache for both her husband and also her parents, right? And so that's the document we're talking about today, the importance of a living will and stating in writing what your intentions are. It's very important. So don't confuse the living will with the last will and testament. The living will is different than the last will. The last will and testament comes into effect when you pass away. The living will is something that comes into effect while you're alive, right, in one of these end stage conditions. All right, I'll be back again tomorrow with another video about another ancillary document. All right, talk to you tomorrow.